the case that changes everything. Once in a decade, the Supreme Court takes a case that redefines how Americans exercise a constitutional right. Heller did it for individual ownership, McDonald did it for incorporation, and BRUEN rewrote public carry standards nationwide. But now the court has stepped into Woolford versus Lopez, a case that could decide whether Americans must keep asking the government for permission to carry at all. The case started in Hawaii, but its outcome could collapse permit systems in New York, Maryland, California, and any state that treats self-defense as a conditional privilege. For the first time, the court bypassed years of litigation and grabbed the case early, signaling urgency and frustration with how lower courts have handled post-BRUEN cases. If the court rules broadly, permits as we know them could disappear. If it rules narrowly, states may lose their loopholes anyway. Either way, this case is not just about Hawaii. It is about who gets to decide how Americans defend themselves, the government or the citizens. Section 1. Early intervention by the Supreme Court. The Supreme Court does not normally enter a case until it has been through trial, injunctions, appellate review, and a final opinion. That long pathway is not a suggestion. It's the traditional workflow that protects the court from acting prematurely. But with Woolford versus Lopez, the justices bypassed nearly all of it. Instead of waiting for final resolution, they granted review at the preliminary injunction stage, a move reserved for cases involving immediate constitutional harm. Why this matters? After BRUEN in 2022, several states began adopting layered restrictions designed to test the ruling's boundaries. New York, New Jersey, Maryland, and Hawaii were at the forefront. Instead of outright bans, they attempted to create functional equivalents through sensitive place expansions, default property, bans, and permit burdens so strict that the right existed only on paper. This caused chaos in the lower courts. Some followed BRUEN closely, striking down these restrictions. Others, particularly in the Ninth Circuit, allowed them to stand. The Supreme Court had already issued multiple summary orders, instructing lower courts to reconsider cases in light of BRUEN, including the New York, Antonyuk, and New Jersey Coons litigation. Those orders were largely ignored or minimized. By intervening now, the court is signaling that it is done waiting for the judiciary to self-correct. Case relevance. BRUEN established text history tradition. Young versus Hawaii showed Hawaii's resistance to public carry before BRUEN. Antonyuk, NY, and Coons, NJ, showed post-BRUEN defiance. Takeaway: when the Supreme Court steps in this early, it is not because they are unsure, it's because they already know the issue demands correction. Section 2. Hawaii's presumption of prohibition. Post-BRUEN, most states rewrote their carry laws by trimming may-issue systems into shall-issue compliance. Hawaii did not. Instead, it flipped the legal presumption surrounding carry on private property. Instead of presuming lawful carry unless restricted, it presumed unlawful carry unless explicitly permitted. The effect was sweeping. Grocery stores, gas stations, parking lots, malls, and other publicly accessible private spaces became off-limits to even licensed carriers by default. Only property owners providing verbal or written permission could override that presumption. Why this mattered legally? It inverted the very nature of a constitutional right. Instead of the government needing a justification to restrict, the individual now needed justification to exercise. Courts have repeatedly rejected similar inversions. In Heller, the right to possess a firearm was not contingent on government approval. In McDonald, the right was incorporated against the states. In BRUEN, the right to carry in public was affirmed as a core component, not an optional privilege. A federal district court applied BRUEN directly and struck Hawaii's law down as lacking historical support. The Ninth Circuit reversed that ruling, reinstating the law and creating a direct conflict with Third Circuit rulings in the New York/New Jersey litigation. Takeaway: Hawaii didn't ban carry outright. It made the exercise of carry legally impossible for ordinary people. That's what forced this case upward. Section 3. DOJ breaks from expectation. Perhaps the most shocking turn came not from the Ninth Circuit or from Hawaii, but from the Department of Justice. Instead of defending Hawaii's law, the DOJ submitted a brief agreeing with plaintiffs that the state's approach exceeded traditional constitutional limits. This is extremely rare. When the federal government refuses to defend a restrictive gun law, it sends a message to the court about constitutional defensibility. Even in controversial Second Amendment cases, the DOJ traditionally sides with regulatory power, but here, it abandoned Hawaii's theory entirely. Legal impact. It stripped Hawaii of authoritative support. It signaled that even under a government-friendly interpretation, the law failed. It strengthened the plaintiff's argument that public carry cannot be treated as presumptively unlawful. The DOJ's position also aligns with historical precedent. Under Bruen, the government must locate an analog between 1791 to 1868, demonstrating that similar broad restrictions existed. No such analogs have been found. Cases. The U.S. government previously defended some regulations in Heller and McDonald, but not blanket bans. In Bruen, the government conceded certain elements of historic carry. Here it concedes the private property presumption lacks history. Takeaway. When the federal government steps back, it clears the runway for the court to rule aggressively. Section 4. Circuit Split Forces Action. The Supreme Court is duty-bound to resolve constitutional conflicts between circuits. After Bruen, the Third Circuit struck down multiple sensitive place restrictions and default bans in New York and New Jersey, Antonioke Coons. The Ninth Circuit upheld Hawaii's model and allowed it to resume enforcement. That was a direct collision. Two federal circuits created two competing realities. On the East Coast, carry is the default. Restrictions must be justified. On the West Coast, restriction is the default. Permission must be justified. The Constitution cannot operate differently depending on geography. The court has intervened in similar splits before. McDonald, Chicago versus National Incorporation. Carpenter, cell phone privacy. Dobbs, abortion jurisprudence split. Once circuits divide on constitutional interpretation, the Supreme Court acts as the tiebreaker and often the redefiner. Takeaway, this wasn't just about Hawaii. It was about restoring one unified interpretation of the Second Amendment. Section 5. Hawaii's legal strategy collapses. Once the Supreme Court granted review, Hawaii pivoted. The state argued the case required more evidence, hearings, and time, an argument it did not make below. In fact, Hawaii previously told the Ninth Circuit the case was purely constitutional and contained no factual disputes. That contradiction mattered. Appellate courts rely heavily on consistency and credibility. Changing the theory midstream suggests that a party is not defending a law, but it's trying to delay defeat. In constitutional law, delay is a strategy, but here the Supreme Court denied it. Hawaii's about-face implied that the state had reached the limit of its reasoning under Bruen. A similar collapse occurred in post-Bruen litigation, when New York attempted to add dozens of sensitive places and property presumptions. Courts repeatedly told the state that creative restrictions are still restrictions. Bruen did not create exceptions, it removed them. Takeaway, by contradicting itself, Hawaii lost control of the narrative and made it easier for the court to push forward. Section 6. The Private Property Gambit. Hawaii's law uses private property to accomplish what direct bans cannot. By presuming carry is prohibited everywhere unless a property owner says otherwise, the state created a system where even licensed carriers must seek permission to exercise a right that should be presumptive. Legally, that puts Hawaii in conflict with Bruen, which requires historical analogies for any restriction. There is no founding-era tradition where the government could preemptively forbid carrying on all private property. Historically, exclusion worked through notice signs, trespass warnings, or direct communication from an owner. In practice, gas stations, grocery stores, malls, restaurants equals off-limits. Parking lots become gun-free by default. A permit ceases to function as authorization. This design transforms property law into a regulatory choke point. If the Supreme Court does not stop it now, other states will adopt the same template. Instead of banning carry, Hawaii banned locations. The effect is identical. Section 7. Bruen is back in the room. Bruen affirmed that public carry is a core component of the Second Amendment. Wolford tests whether lower courts will apply that standard faithfully. Here's what Bruen changed. No more balancing tests. No more public safety policy arguments. Restrictions must match the founding-era history. After Bruen, the Third Circuit followed that framework. The Ninth Circuit didn't. That divergence is exactly why Wolford reached the Supreme Court. Short point. Wolford is not merely a challenge to a Hawaii statute. It is a challenge to the idea that lower courts can water down Bruen through creative theory rather than direct disobedience. Section 8. The lower court problem. The Supreme Court issued multiple GVR orders after Bruen, telling lower courts to reconsider cases under the new standard. Some courts complied, some resisted, others reinterpreted Bruen into something it never said. Wolford gives the court an opportunity to reassert control and remind the judiciary that Supreme Court precedent is not advisory, it is mandatory. Hybrid impact. If the court does not address misapplication now, Future Second Amendment rulings will fracture into regional systems a constitutional right. That means one thing in California and another in Pennsylvania. Short takeaway: rights cannot depend on zip codes. Section 9. The permit question looms. Woolford is not directly a permit case, but its logic touches the permitting structure nationwide. If the court rules that carry is presumptively lawful on private property, then permits that function as prior restraints become harder to justify. Permits survived BRUEN only because the court tolerated objective screening. But if carry is a default right, the role of a permit shrinks dramatically and in restrictive states could collapse entirely. Real stakes: New York, New Jersey, Maryland. California equals heavy exposure. Constitutional carry states equals strengthened. Gray states equals forced to pick a side. If Woolford is broad, the permit era could end without the court ever mentioning permits directly. Section 10. What comes next? The court has accepted the briefing. Amici filings are underway. Oral argument will follow. A ruling could arrive within months. Two possible outcomes. Narrow: strikes Hawaii's inversion, preserves permits. Broad: establishes carry as presumptive, destabilizes permit systems nationwide. The court knows the stakes. Lower courts know it. Hawaii knows it. So do the states waiting to replicate its approach. Short takeaway: Woolford versus Lopez is not about Hawaii. It is about whether the government can still force Americans to ask for permission to defend themselves. The permission question. No matter how the court rules, Woolford versus Lopez asks the single most important Second Amendment question of our time. Do Americans need the government's permission to defend themselves? For decades, the permit system assumed that the answer was yes. BRUEN shifted the burden. Woolford could eliminate it, not by abolishing permits directly, but by redefining self-defense as a default condition, rather than an exception. That is what makes this case different. It is not about Hawaii, not about property signs, not about technical rules. It is about who decides the boundaries of freedom, citizens, or the state. The briefing is underway, oral arguments are coming, and the opinion could arrive faster than anyone expected. Whatever happens next, the ruling will establish how far the Second Amendment travels beyond BRUEN and whether the era of permission-based carry is ending. Stay aware, stay informed, and stay engaged. If you found this valuable, make sure you subscribe and stick with us as this case moves forward. The court is not done, and neither are we.